Hello all, today I'll be discussing nuisance. Myself, Sushmita Das, Assistant Professor of Law in School of Law and Legal Studies, Sage University, Bhopal. What is nuisance? The word nuisance has been derived from the old French word which means nuire. So you have to remember that it is not a Latin term. It is a French term nuire, which means to cause harm or to hurt or to annoy. The Latin word the nuisance means to nocure, which means to cause harm. Nuisance is an injury to right of a person's possession of his property to undisturbed enjoyment of it and results from an improper usage by another individual. You need to learn the essential elements of nuisance. First, there should be a wrongful act, and another one is damage or loss or annoyance which is caused to another individual. So, the definition given by Stephen and Salmon. First, the definition given by Stephen, which means that he stated that nuisance is anything done to hurt or annoyance of the tenements of another or of the land, which means which doesn't amount to trespass. Another one is Salmon. Nuisance consists in causing or allowing to cause without lawful justification the escape of any deleterious thing from one's land or from anywhere into land in possession of the plaintiff, such as water, smoke, gas, heat, electricity, etc. Kind of nuisance, public nuisance. The Indian Penal Code defines nuisance as an act which cause any common injury, danger, and annoyance to the people in general who dwell or occupy the property or in which must necessarily cause injury. So, public nuisance affect the society at large. The public, the people living in it as a large or some considerable portion of the society which gets effect from that right which the members of the society might enjoy over that property. Next one is private nuisance. In private nuisance is that kind of nuisance which a person's enjoy or use enjoyment of his property which is ruined by another. It may be injuriously affected by the owner of that property by physically injuring his property or by affecting the enjoyment of the property. First, you should know the essential elements of a private nuisance, which constitute nuisance, private nuisance. First, there should be an interference which must be unreasonable or unlawful. Such interference has to be with some use of enjoyment of land or some rights over the property. It should be in connection with property or physical discomfort. There should be a feeble damage to the property or with the enjoyment of the property in order to constitute private nuisance. Nuisance and trespass. You should know the difference between a nuisance and trespass as they are quite similar. It is an injury to some right of the possession of the property but not possession itself. So you have to learn that in nuisance, the possession, that place is very important. So here it can be a public place or it can be a private place. So it is thus place, it is an injury to some right of the possession of the property, but not possession itself. And in trespass, there is a direct physical interference with the plaintiff possession. Here, the possession is very important term. Plaintiff's possession of that property through some material or tangible object. So there are certain remedies, that is injunction, damage, and abatement. Thank you.